Actually, I wanted to ask you, my name is Vladimir Kowalski, I'm the head of the consular section at the Embassy of the Republic of Poland. And I actually wanted to ask you about three things that you mentioned. First, thank you for, because I think it requires a lot of courage to come and speak about that subject in front of the Polish audience. And I'm actually very grateful to you, because in our experience it's very hard to have anybody from the Barnevernet who is willing to at least enter into a discussion. Therefore, thank you really indeed for that. My comments go towards, you mentioned the biological principle, and I'm very happy that you say that, because for many of the Barnevernet people it's not obvious. It's still the basis of the Norwegian law, yet since the Norwegian official report number 5 of 2012, when the Commission of Experts recommended to drop the biological principle in favor for the emotional attachment, developmentally supportive. Well, then I think many people in Barnevernet followed that report rather than the law. Right. The other problem that I'm quite happy that you mentioned UN Convention on the Rights of the Child, because that's where we have most of our problems, especially with respect being paid to Article 8, with respect being paid to Article 14, and respect being paid to Article 20.
I'm not familiar with article numbers.
Sorry?
I'm not familiar with all the articles.
Oh, I'll briefly tell you what it is about. The Article 8, which is the biggest issue, is the right of the child to preserve its identity. Identity in terms of name, nationality, and family relations. That's a very important part of family relations. And that's where we really have most of the problems, because whenever we ask, we never had the case when Barnevernet was, according to the UN documents, because the convention refers to a declaration, which is earlier in the preamble, which clearly says before you put the child in the foster care, you have to consider and search for possible foster parents among the biological parents' relatives. That's never been done.
On what grounds do you say that it's never been done?
Well, on the basis of the replies that I received from different Barnevernets, and on the basis of their documents they produce. Because in many cases these children have relatives in Poland. And whenever it comes to, and actually there is surprisingly not at all any willingness to refer to the Polish authorities in order to search for that, though we have a convention that bridges it, the Hague Convention on Taking Evidence Abroad, and yet it's never being used. Although we suggested that a number of times. When then the Article 14 that we discussed is the fact that since most of the cases when the children are being taken away from the family are based either on the paragraph 4.6 of the Barnevernet law, or paragraph 4.12 of the Barnevernet law, it is actually the situation that the parents are deprived of the daily care, but not parental responsibility. And therefore, as parents, they have the right to decide on and have the leading role on the issue of the child's fate. And the Article 14 is about that the state signatories are actually obliged to respect the parents' leading role. In at least 4 cases, there are difficulties because the Barnevernet has problems to respect the Catholic faith. Difficulties to bring the child to the church. Sometimes the liturgies are broken because of the fact that the children are being placed in the families that are not Catholic at all. The Article 20 is just about that. It's respect for the continuity of the upbringing environment in terms of nationality, culture, language, and religion. I think language is the biggest issue. Well, in most of the cases, the children basically stop speaking Polish because they have no contact at all. And I don't want to further elaborate on that, because what I still have to add is also with the our practice as consular officers, actually Barnevernet never or very rarely respects the rights that are actually conferred to us in the Vienna Convention on Consular Relations, especially Article 5H, Article 36, and Article 37B. And that is actually information regarding the child, access to the child based on the Article 36, because it's a child is in custody, it's the citizen of Poland. And the information, especially when there is an issue of legal, not daily care, but actually establishing a legal guardianship. And we had 2 cases when actually the institutions never did it, although they made a decision.
Sir, can I stop you? Because
yes.
I've only been allocated 20 minutes.
Okay, it's just to say that, and, yeah, I will not comment anymore. Thank you very much. Excuse me, can I actually elaborate on that a bit, just to make you understand it better? Actually, if you look at the roots of the Barnevernet system, the first act of the Barnevernet is actually 1896. You're aware of that, I'm sure. 1896, the end of the 19th century. That was a crime prevention tool, and I'm sure you know it. It was considered that in certain areas, especially at that time, it was considered the poor suburban families living in the cities. The children were growing in a criminal environment and were growing up to be criminals. So they had to be taken away and placed into other families where they could grow as good citizens. That is a tool to prevent society. That was a tool at that time to prevent society from bad, let's say, effects of growth of the children.
But are you aware that the new law was written in 1992, which is the law that we're working with today?
Don't take it personally.
I'm not taking it personally, but you're talking about a law that was written in 1896, and I'm talking about one that was written in 1992.
It was amended twice. In 53 and 92, you know. But the question is about whether right now, because obviously we discuss right now, and your presentation is very fine to us, because it talks about theory. Now we're actually, especially in our work as the embassy, have practice rather than theory. And there are big discrepancies, therefore we're trying to look for the motives, and that's why His Excellency Ambassador posed that question. Because actually intelligent people cannot escape a certain suspicion that perhaps the spirit of the first legislation is still present. And in many practices of the Barnevernet, protection of the society against unwanted effects of immigration is more important, or at least equally important, as the interest of the child. And the interest of the child is perceived from that perspective of protection of the society. Because otherwise, certain issues like disregard for faith, disregard for language, disregard for culture would not have happened. And you know, actually, there's a case that is interesting to exemplify that. It's the case of Sasha Frolov. And that's what you can understand the difference between Polish mentality and the mentality that is applied in Norway, where the child arrived in Poland. Actually, the Polish parallel to Barnevernet, Polish Child Welfare Service, placed the child in a foster care who was a Russian citizen, in a Russian-speaking family, Christian Orthodox family, whereas the child was deprived of all that in Norway. So the question is why the child should be deprived of its identity in terms of culture, religion, and language.